And welcome to the EDRM Global Webinar channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery Today's Doug Austin. It's the important eDiscovery case law decisions for July 2023 with our faculty experts, of course, Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console, and questions will be answered both during and at the end of the webinar. And this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Now, this is our new On24 platform. Some of you have been here before, but a little introduction to our engagement tools. We've got more ways to engage. So if you look down at the bottom of your console, you'll see the engagement tools. The media player is what you see right now. The little cartoon question mark that's the place where you put your questions in, and we'll be able to answer them in the moment in writing if it's like a technical question or something like that. The slides, today's presentation, you'll get the link to the slides from Doug Austin after the webinar. There's a paperclip for related content. We'll cover that in a bit. Speaker bios that you can refer to, latest news, a question mark if you have some technical help, and then just like Zoom, we've got reactions, smiley face emojis, thumbs up, etc. That you can use. So you just click into there, and there's actually a little doc in there that'll show you what's available to you. You can follow us on social, book a meeting with us, contact EDRM via email, and at the ribbon, you can download a certificate of attendance from the engagement form after the webinar. And Kaylee Wolstad, our EDRM's Chief Strategy Officer, is here with us. Could you let us know what resources are available for our listeners today?
Absolutely. If you look in your engagement tools at the paperclip and click it open, you'll see, number one, our engagement tools descriptor, which can help you better interact. And we highly encourage you use the reactions. We've had a lot of fun with those, and it's a great way to engage. Save your seat for next month's important eDiscovery case law decisions for August. Be sure to do that on August 30th. And then there's a link to subscribe to eDiscovery Today, and a link to check out Tom O'Connor's latest book, eDiscovery for the Rest of Us. And then up next, there's also a link for Judge Peck.
Of course.
Yes, I almost forgot the Honorable Judge Peck, and learn ways to engage with him. And then up next on EDRM's webinar channel, Carpe Data, Stop Control Effing Transcripts and Use Testimony Intelligence, August 7th. Back to you, Mary.
Thanks, Kaylee. And our speakers and faculty, Doug Austin. Doug Austin is the founder and editor of eDiscovery Today. Doug's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. And Tom O'Connor, hailing from the great city of New Orleans, for over 3 decades, Tom has stewarded the Gulf Coast Legal Technology Center. He's written a new book on eDiscovery, as Kaylee had mentioned, eDiscovery for the Rest of Us, that you can find on his Techno Gumbo blog that I can hardly pronounce, Tom. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright, trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions. And then later, of course, we've got boilerplate objections, 502D orders, and technology-assisted review. And without further ado, Doug, take it away. We've got cases.
Indeed we do, Mary, and thanks. Happy July 32nd, everybody. and welcome to our July case law webinar on the EDRM network. We have another set of very interesting cases this month, including custody and control of a personal Google account, self-collection and privilege status of search protocols, unsealing a motion for sanctions, sanctions for wiping cell phones after a duty to preserve, application of Rule 26b1 proportionality factors to video evidence, and production of original metadata to replace altered metadata. We also have a bonus case lesson from a past case. And just a reminder, as Mary mentioned, we do welcome questions and we'll try to get to as many as we can. And I will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. That's true no matter what month it is. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 31,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. But wait, there's more. July marked the 3-year anniversary since we started doing these case law webinars. And believe it or not, we've discussed over 200 cases since we started. So I just want to take a moment to thank Mary, Tom, Judge Peck, and Kaylee for making it possible every month, and to thank all of you who supported us and joined us every month. So we are on to 300, moving on from here. And with that, let's get into the cases. Our first case involved alleged violations of provisions of the Securities Act of 1933 over the sale of cryptocurrency tokens, and was suggested by Judge Peck. Mr. Lee was the defendant's director of operations and one of 3 members of its board of directors, but not a defendant in the action. Lee's Elastos Google account was searched in connection with this action, resulting in the production of over 13,000 documents. In total, more than 30,000 documents were produced from various Lee sources, including his laptop, phone, and personal WeChat account. However, when he was asked for permission to search his personal account, he refused. Discovery showed that Lee received 2 emails concerning a personal investment at his elastos.org email address and forwarded them to his gmail.com email address. On one occasion, he received an email concerning Elastos business at his gmail.com email address, which he also forwarded. Plaintiffs argued that, at a minimum, the previously agreed upon search terms should be run across Lee's entire personal account to determine whether there were any further hits. New York Magistrate Judge Barbara Moses stated, "The parties' dispute presents 2 questions: whether Mr. Lee's personal Google account is within the control of defendant Elastos, and if so, whether the discovery sought would nonetheless be disproportional to the needs of the case." Noting that the burden of demonstrating that the party from whom the documents are sought has the practical ability to obtain those documents lies with the party seeking the discovery, Judge Moses stated, "In this case, plaintiffs have not met that burden," stating that defendants have requested multiple times for Mr. Lee to provide access to his personal email account for collection and search, but he has refused. Judge Moses stated, "On balance, I cannot conclude on the present record that Elastos controls Mr. Lee's personal Google account. Plaintiffs have not shown on the present record that they are entitled to an order compelling Elastos to search Mr. Lee's personal Google account." So, Tom, do you think a non-party should be forced to have their personal email searched when there's evidence of any work emails within it? Or do you agree there weren't enough work-related emails to compel searching the personal email account here?
Well, I think the judge here laid out the twofold test. First, that practical control before we even think about proportionality. If it's a personal account, did the employer have, in fact, some sort of practical control? And she clearly said that that burden had been met. But then secondly, no. I mean, as I recall in reading the decision, there were only 2 emails that were found that seemed to touch on the business, and Mr. Lee had forwarded one of them to one of his business email accounts, and it had been produced. So, no, it didn't seem to pass the proportionality test. And I think parenthetically, as you mentioned here, I think you mentioned in the text here, Mr. Lee had cooperated. The judge said he had been fully cooperative in discovery and had been working and everything. Just kind of drew the line in the sand at his personal email, and here in this case, I think rightfully so.
Yeah, it certainly seemed like a couple of extraneous emails wasn't enough to compel it in this case.
Yeah.
So Judge Peck, do you think the plaintiff should have pursued discovery of Lee's personal Google account through a Rule 45 subpoena instead, or would that have likely to have been quashed in this situation?
Well, remember in the In re Pork antitrust case that we discussed a few months ago, or maybe a year ago now, that's exactly what the requesting party did. Tried to get it from the corporation, but in the belts and suspenders approach, issued Rule 45 subpoenas to the employees. The problem here is Rule 45 does not go extraterritorial. And Mr. Lee lived, presumably, certainly worked, and therefore presumably lived in China. No way Rule 45 is going to apply in that situation, even putting aside, Chinese blocking statutes and privacy statutes and the like. So yeah, had he been a U.S. Resident, quite possibly a Rule 45 subpoena would have worked. But then, as Tom was talking about, with so little evidence that there was likely to be anything in his personal account, proportionality likely would have resulted in it being quashed anyway. And just a point of emphasis, this is even under the very liberal, shall we say, Second Circuit standard of practical ability to obtain information, as opposed to the Ninth Circuit legal right test that we've talked about in many of our prior webinars here.
Yeah, absolutely. Question from the audience: could the company be faulted for corporate controls to limit the use of personal mail for business purposes? Certainly didn't sound like the court did so here. Thoughts on that?
We don't know what the corporate policies are, but the policies only go so far, and there was essentially no evidence that he was using his personal account.
Right. Yeah, it seemed like more kind of happenstance than anything. So absolutely. So Mary, one of the things that I found interesting about this case was the second footnote in the ruling, which identified some agreed upon very broad wildcard terms. One of them was APP with a wildcard, one was Communa with a wildcard, and one was VOT with a wildcard that Judge Moses stated could hit on innumerable emails and documents completely unrelated to Elastos's business. So do you think the plaintiffs might have been successful if the terms were more properly scoped?
Well, possibly, but knowing instinctively that whatever the search hit reports came back with would engender more court time, because these certainly are, just instinctively overbroad. But I think what I'd like to do is cede the rest of my time to you, Doug, because you've got something on this.
All right, fair enough. I will first, since we have one more question before we move on, got a question here. Would a Rule 45 subpoena to Google have been an option? Thoughts on that?
I believe under the Stored Communications Act, without Mr. Lee's consent, Google could not, particularly in a civil action, we're not talking government investigations or criminal cases, Google could not have turned over the content of the account.
All right, fair enough. So, as Mary indicated, and I mentioned at the intro, we kind of have a bonus case to talk about here because the previous case used the exact search term example I use in my project management presentations. And so this is a case I covered a few years ago. Tom, I think you and I discussed this case on a webinar back in the day. And, and it involved parties agreeing to several search terms, including the two you see here: smartphone with intent of app with a wildcard, and phone wildcard with intent of app with a wildcard. And basically, it seems as though what they're looking to try to do here is to find documents that relate to phone and smartphone apps, application or applications, right? At least that's what I think. So there are more words, however, that do begin in the English language that begin with that. How many are there? There's this many. And this many.
What's appoggiatura, Doug? Come on.
And this many. Hey, come on, a little suspense here. There's 308 words that begin with app, and 304 of them are bad. Apparently, it appears the application of the search terms were thought to be appealing when they weren't approximate or even appropriate. They were appalling.
Oh, dude, please.
Come on now. Anyway, this is known as getting wild with wildcards, and it's something I see all the time. Much better search would have been the one you see there. Actually, they should have been consistent with their use of wildcard on smartphone and phone, but we'll bypass that. Now, the dispute in the case was over whether the defendant had to produce all the documents responsive to the search results. Texas Magistrate Judge Andrew Austin, no relation, ruled that they didn't have to do that, but they still had to review them all, which was honestly probably punishment enough. Certainly one of the things some of you might be thinking is, what kind of nerd knows there's 300 words that begin with app? And the answer is Scrabble players who use this site called More Words. And it's a very useful site, not just for them. As you can see there, you see some of the words with their Scrabble scores next to them. It's also useful for testing wildcard terms. And so what I've done here is I've provided links to a words that start with and a words that end with example, and all you'd have to do is replace the APP or the ING with the term you want to test. So literally a 20-second search here could save thousands and thousands of potential review costs by catching those wildcard terms that are too wild before you agree to them. And both parties obviously agreed to that clearly overbroad term, not just in this case, but that I'm going back to, but our first case as well. So just something there to kind of give you a sense of a little tidbit to use going forward. And with that, let's get back to our regular cases. So in this next case, the plaintiffs moved to compel electronic searches of defendant Ford Motor Company's records associated with 4 custodians. The motion was referred to Michigan Magistrate Judge Elizabeth Stafford for hearing and determination, after which her ruling was provided at the top of her order, where she stated, the court detailed its reasoning during the hearing. To summarize, Ford provided a vague description of its search methodology for most of the custodians, and it claimed privilege for testimony that plaintiffs said proved that Ford's methodology was too custodian-driven. Although there is conflicting precedent, this court announces in this order that it agrees with opinions emphasizing that electronic discovery requires cooperation between opposing counsel and transparency in all aspects of preservation and production of ESI. She also stated, and this court has already held, that an attorney may not simply rely on custodian self-collection of ESI. Instead, counsel must test the accuracy of the client's response to document requests to ensure that all appropriate sources of data have been searched and that responsive ESI has been collected and eventually reviewed and produced. And she also said this, the court also rejects any argument that a party's search protocol is privileged. It would go against reason to find that the steps a party takes to identify responsive documents are privileged when those steps result in an evasion of discovery obligations by not collaborating on their discovery and ESI search strategies. She concluded her ruling by stating, finally, despite Ford's claim that it made a full production of responsive documents, the limited production from key custodians permits a reasonable deduction that other documents may exist. So she rejected defendant Ford Motor Company's reliance on self-collection and rejected any argument that a party search protocol is privileged, granting plaintiff's request and ordering the parties to have transparent and cooperative discussions about the search terms and search methodology. Self-collection was not one of Ford's better ideas. So Judge Peck, isn't a request for search terms discovery on discovery, and shouldn't the plaintiffs have to prove issues with the document production to get to those?
I suppose my answer is the usual quote, it depends. But, while I am not in favor, believe me, of discovery on discovery, but if you don't know what search terms the opposing party was using to get to information, you can't know if they missed things or not. Search terms are terribly constructed, even without wildcards. But if you don't know what the other party is using, to me, that's not a discovery on discovery. That is something that in the 26F meet and confer or subsequent meet and confers, the parties should be at least reviewing whether the requesting party gets a say in it or not. One could debate those things. One other point on self-collection. I know Ford is a big company with lots and lots of outside lawyers, but this is not the first case where they have been chastised by the court for employee self-collection. Going back well before the 2015 amendments, I think the case was Bird against Ford Motor Company.
Right.
I remember concepts better than case names, but I think that was the one. And they got roundly chastised for self-collection.
I do remember. I didn't actually have time to go find what case that was, but I do remember covering that case years ago. So yes, apparently they're still doing it. So that brings up a great question, Mary. Why do you think even large organizations like the defendant in this case, like Ford Motor Company, choose to have custodians self-collect? Is it a cost issue, or could it be something else?
Well, it's always a cost issue. IT collection or collection by third parties, that's an unfunded mandate inside IT, and then you have to pay the bill if you're collecting third party. But it's also, they may want only their own employees to see their own email and to give that voluntarily by demonstrating trust in their employees. That's possible. They could also trust that their employees will filter out the bad. And I have seen it where some organizations just flat out don't trust their attorneys. It sounds paradoxical, but sometimes from the top, they would prefer to control those mechanisms. And when you refer to preservation by custodians, when custodians decide what to preserve instead of being guided by their counsel, I've nicknamed that self-preservation.
Indeed. Well, I'm in favor of self-preservation for a variety of contexts, but certainly that's a good point there. So Tom, one of the things, obviously, this dispute was kind of well down the pike. And Judge Peck mentioned it. Would agreeing upon an ESI protocol early in the case during meet and confer have helped avoid this dispute, or at least force it to have been addressed earlier?
Well, yeah, but good getting that done. I mean, first of all, early in the case, I rarely, if ever, see an agreed upon ESI protocol, and getting one out of the meet and confer, at least the first round of the meet and confer, is also like pulling teeth in my experience. So although that's helpful, I don't think that's going to happen early in the case. That being said, there are other things that can be done. Of course, initial disclosures are on the table, and you can be talking to the other side. There was a great article last week online. Sharon Doherty of Reed and Smith had one called ESI Consult Before Entering ESI Protocol Agreements. And she said, you don't have to wait for the actual ESI protocol to become written in stone to have the discussions amongst the attorneys and the analysts and the consultants about what you're going to do. And she even referred to a case that discussed that, in re StubHub refund litigation, which is a Northern District of California case from April of this year. So, I think the point is, don't wait on a protocol. Get the discussions going. Talk early, talk often, right?
Yeah, absolutely. Yeah, and obviously the pushing the protocol kind of maybe forces that discussion early, but yeah, certainly doesn't. You don't want to have to wait on the protocol. And of course, the StubHub case you mentioned is one we covered last month. So
yep.
That was an interesting one where ESI protocol was very instructive in that decision. So folks, feel free to go check out last month's recording to check out our discussion on that. In the meantime, we'll move on to our next case, which in which the plaintiff sought to unseal the brief and exhibits in support of his motion for imposition of sanctions, which sought a default sanction against the WellPath defendants, which was one of two defendant groups. The other one wasn't involved in that motion. The WellPath defendants objected to the unsealing of 14 of the sealed exhibits and to the unsealing of the portions of plaintiff's brief that discuss those exhibits. Beginning her assessment of the dispute, Oregon District Judge Ann Aiken stated, although the parties both present arguments under the compelling reasons standard, the court concludes that the proper standard is good cause. Here, the issue is the WellPath defendants' conduct in meeting, or rather failing to meet, their discovery obligations, and more particularly their duty to preserve relevant materials for discovery. This is tangential to the underlying claims, and so the court determines that the good cause standard applies. Judge Aiken rejected the WellPath defendants' claim of attorney-client privilege on 12 exhibits, stating, any privilege that once attached to these exhibits has been obviated by the WellPath defendants' decision to disclose them to plaintiff in discovery rather than assert the privilege. And she rejected their claim that two exhibits contain proprietary information and trade secrets, stating the WellPath defendants make no effort to show that any specific harm or prejudice will result from the disclosure of exhibits 37 and 91. So Judge Aiken found that the WellPath defendants have failed to make the threshold showing necessary to establish good cause to continue the protection of those exhibits. However, she also still applied the 7 Glenmead factors you see in the third bullet point there, stating the court concludes that while the WellPath defendants have a privacy interest at stake and the disclosure of the challenge exhibits may be embarrassing to them, these considerations are substantially outweighed by the remaining factors. So, Mary, did the WellPath defendants drop the ball by making no effort to show harm or prejudice from disclosure of the two exhibits, or would it have mattered given the court's application of the Glenmead factors as well?
Oh, I think it was really important. It was mentioned more than once that harm was not demonstrated. So I think this is one of those situations where you have to show your work. You can't just make assertions and expect that the court will intuitively know that that is true. You have to show something. And in this case, it was harm and they didn't do it. And I think that outweighed the embarrassment.
Sure. Yeah, it certainly seemed to. So Tom, in your experience, how common is it for parties to attempt to seal motions like this? Does the type of motion influence whether a party would attempt to keep it under seal, or is it more about the potential information disclosed?
Oh, very common, but I think it's about the information. I mean, extremely common when there's, as here, claims of proprietary information and trade secrets in cases that have that sort of information. But then also, claims of privacy to avoid embarrassment come up all the time. And the judge here rightfully pointed out, well, that's outweighed by the other factors. So it's something we can look at. But, you know, I mean, you get the Sarah Silverman versus OpenAI case that's going on now, and several other OpenAI and artificial intelligence cases where Silverman, in her case, you know, is suing for use of her copyright information in productions that are made by an OpenAI product, and they ask for a protective order against all the items that they serve. So they're asking for a protective order against disclosing what copyright information they have in their data banks. Mm-hmm. Technically, they're in third party. It turns out they're actually all using third party accumulated data banks, some of which are using BitTorrents to accumulate those. So it's going to be really, really messy. But yeah, very, very common. People are going to ask for these all over the place. I'm interested in the judge's perspective on how much hair pulling was going on in reading these sorts of motions.
Yeah, absolutely. Well, so Judge Peck, one of the things I was interested about is that this is an Oregon case, which is in the Ninth Circuit, but Judge Aiken applied Glenmead in a Third Circuit case as part of her justification of her ruling. Is it common for courts to cite other circuit rulings? And if so, are there guidelines for when they generally apply them?
Well, I can jokingly say that it's not common because very little of the circuit decisions deal with eDiscovery when we're talking about discovery-related issues. But, you know, less colloquially, all courts are bound by Supreme Court decisions until the Supreme Court changes its mind. Then they're bound by the circuit court of their circuit, and that's it. Whether it's another district court decision in the same district or within the circuit, or a circuit opinion from outside, it's whatever is not binding. It is not binding, but it can be persuasive authority. So when there is no instruction from your circuit and there is a helpful standard from another circuit, courts can and often do borrow it. I do want to point out one other thing, and that is that there is a difference between the standard for a protective order for the material exchanged between the parties, but not presented to the court. That's a much more liberal standard, particularly if the receiving party doesn't object. But there has to be a higher standard to seal records that are actual court records. And the Sedona Conference did a commentary on filing under seal within the last year that I invite people to go take a look at for the case law with respect to that.
Okay, oh, great point. And certainly one of the things I'll be on the lookout for is an eventual ruling on the motion for imposition of sanctions, because I have a feeling that since it's they're seeking a default sanction, it could be interesting since it has to do with discovery and preservation. So we'll keep an eye out for that. Right, and we'll move on to our next case, which was an employment discrimination action filed by a disabled biology professor whose contract wasn't renewed following his second year evaluation. And by the way, hat tip to Michael Berman, who wrote about it on the EDRM blog. The plaintiff sent a roughly 60-page rebuttal letter to Dean Campbell and appealed her decision to Provost Throop, who ultimately recommended the non-renewal of plaintiff's contract after expressing concern that the adverse decision might not be defensible in court. The final decision not to renew plaintiff's contract was made on December 13, 2018. The plaintiff filed a charge of discrimination with the EEOC on March 20, 2019, and subsequently filed suit on October 30, 2020. And those dates and events are key to this ruling, which is why I got specific with them. Just before the close of discovery, defendants admitted that they had destroyed relevant evidence when they erased the university-issued cell phones of Dean Campbell and Provost Throop, which occurred when each left their respective positions within the university. Plaintiff filed a motion for sanctions based on spoliation of evidence. In considering duty to preserve, Maryland District Judge Ellen Hollander stated, Defendant's obligation to preserve evidence in general indisputably arose on March 19, 2019, when defendants first received notice of plaintiff's EEOC charge. However, she also stated, plaintiff's written appeal of the non-renewal decision expressly raised the subject of discrimination, and that defendant's clear understanding of the discrimination allegation is further supported by Provost Throop's reaction to the written appeal. Throop's concern that the decision might not be defensible in court implies that, based on the written appeal, defendants anticipated the possibility of litigation. So she concluded that defendant's duty to preserve actually occurred when the plaintiff submitted his rebuttal letter in November 2018. Good news for the plaintiff? Not so fast. Judge Hollander also stated, in order to impose sanctions for spoliation of ESI, the court must conclude that defendants engaged in willful or intentional conduct. Here, however, plaintiff has not provided any evidence that defendants deleted the contents of the cell phones with the intent to deprive plaintiff of any evidence contained therein. As far as I can tell, plaintiff argues only that the data was improperly deleted and that the intent element is satisfied by the experience and knowledge of Dr. Throop and FSU counsel with respect to litigation procedure. So Judge Hollander denied the plaintiff's sanctions motion. So Todd, should the plaintiff have pursued sanctions under Rule 37E1 instead, or as an alternate sanction if he didn't get 37E2 sanctions?
And I don't know. I'm still trying to read through Judge Hollander's 75-page opinion here. Figure it out.
Right.
It's a very weighty, well-reasoned, almost academic opinion that goes back, quotes Judge Grimm at one point and Victor Stanley. She clearly dove into the details in the substrata of the E2 argument. E1, I think, would have been difficult. Remember, 37E1 says, upon finding a prejudice to another party from the loss of information, the court may order measures no greater than necessary to cure the prejudice. Well, here, as you noted above, they only found out about the missing cell phones shortly before the close of discovery. I'm not sure that was going to be enough time for them to mount an argument about how they were prejudiced from missing information off those cell phones, and then, would any curative measures out of that, been enough, assuming that they figured they'd get more out of the 37E2 argument. So I don't know that they would have gotten. I don't know that they could have gotten far, given how late in the discovery this all happened, and whether it would have gotten them much anyways.
Yeah. So I agree with you. I certainly, a couple of notes to your comments. It was a long ruling, but it was ruling on multiple things. We picked one issue out of it, of course. Yeah, but it was
well written. But
yes, it was a very well written opinion, and this was one of the issues being addressed within it. But one of the things I did note is there didn't seem to be a lot of discussion about how what the extent of prejudice.
No.
So that was one of the things I was wishing there was more discussion of. But again, like you mentioned, Tom, it could have been the timing of how late that was disclosed, which is always interesting. So certainly notable there. So Judge Peck, I found it interesting that Judge Hollander disregarded the plaintiff's contention that the intent element is satisfied by the experience and knowledge of Dr. Throop and FSU counsel with respect to litigation procedure. Shouldn't experience and knowledge make it more likely there was intent to deprive, since the parties should know better?
It's tough to do that sort of determination. Were counsel do experienced counsel get held to a higher standard, or then we have the cases where counsel hasn't gone beyond learning how to deal with email and they don't know what the hell they're doing? Tough choice. They could know what they're supposed to do and still be negligent in not putting on a legal hold or not being sure that phones were being preserved in some way when the person either leaves the university or at least leaves their post. It goes back to the decision we covered a while back, where Judge Ian Johnston said, well, we'll let the jury decide. Maybe it was intent. Maybe counsel were and the client were just extraordinarily negligent. Tough call.
Sure.
But clearly they didn't show a direct intent to deprive. Not sure whether, going back to what Tom was saying, if plaintiffs had asked to redepose the two employees whose cell phones were destroyed, would that have gotten them anywhere under the 3071 rubric? But we are seeing, I think, a lot of cases where parties go for the 37E to kill and therefore don't get anything.
Mm-hmm. Yeah, certainly seems like we are. And we have seen some cases where they've fallen back to 37E1 as a possibility. So it is interesting. So, Mary, if failing to apply a litigation hold at the proper time is negligence, like Judge Peck mentioned, and not subject to severe sanctions, why would any party be motivated to apply a litigation holds in a timely manner?
Well, fear isn't the only motivator. What about the will to win your case? Legal hold drafting forces the attorney to define the claims and defenses, the time periods, the custodians, the supporting data, potential witnesses, custodians. It's also a cheap and low-risk way to demonstrate good faith. It protects the attorney from ethical issues, potential malpractice issues, and it may save the docs that you need to win. And why would you want to litigate on administrivia rather than the merits? So why not just do it?
Certainly, certainly great points. And they're obviously, we spend a lot of time in this industry talking about the importance of a good legal hold here. So those were some great points as to why you need to do it. Question from the audience here. Does the court consider sanctions through inherent authority, since the data loss here seems egregious, though agreed it doesn't meet Rule 37 threshold? Thoughts on that question?
The advisory committee notes to 37E, although some judges or former judges disagree, say that if it's something that is covered by 37E, the court should not or cannot use inherent authority. This one, I guess, what is egregious is in the eye of the beholder. This, to me, is not like a case where the party was creating evidence or destroying evidence in such a way as to totally frustrate justice. I would not have seen this as a case to use inherent authority.
Okay. All right. Great point. And thanks for the question. We'll move on to our next case, where Connecticut Magistrate Judge Maria Garcia conducted a detailed walkthrough of the 6 proportionality factors in Rule 26B1 to make her ruling regarding whether the plaintiff was required to produce video journals produced by and in his custody. Her assessment of the first 5 factors are in the sub-bullets you see here. In each, she found the factor to weigh in favor of disclosure. She found that for the importance of the issues at stake in the action, given his statement that he cannot function in life while admittedly traveling to numerous countries and doing numerous things. She found that for the amount in controversy, because the amount sought was over $5 million, plus double or triple damages. She found that for the parties' relative access to relevant information, even though the plaintiff claimed it would be unduly burdensome to review over 23,700 videos because he didn't claim they were inaccessible. She found that for the parties' resources, because plaintiff had already incurred the expense of transferring the videos to a separate hard drive and had 2 law firms representing him with plenty of resources. And she found that for the importance of the discovery in resolving the issues, as the parties did not dispute the importance of these videos depicting plaintiff's injuries, symptoms, and recovery from the accident. As for the final factor, whether the burden or expense of the proposed discovery outweighs its likely benefit, she mistakenly said burden in her ruling. The plaintiff estimated that if counsel took 2 minutes to review each video, it would take 790 hours to review all the videos. But defendants argued there is no burden to produce the videos as they can be posted to a cloud-based server. Judge Garcia stated, plaintiff made no showing to support his claim of burdensomeness until after defendants sought court intervention. Moreover, defendants state that at his deposition, plaintiff testified that he did not make the videos to communicate with counsel. Thus, review for privilege is unnecessary and an obstructionist tactic. Because the requested videos are relevant and because plaintiff has failed to demonstrate burden, his objection is overruled. So she ordered the plaintiff to produce not all the videos, but produce responsive videos for the first 14 days of each month. So Judge Peck, we've covered several proportionality disputes over the years, but this is only the second time I can recall a court walking through the 6 proportionality factors and making their determination. Why do you think more judges don't do this, and would you do it in cases like this?
I mean, I think it's often just implicit, and the court goes, at least in the written opinion, to the most important factors, which is usually the 5th and 6th factor. You know, how relevant is the material, and a weighing of benefit versus burden. A lot of the other factors are squishy. You know, plaintiff seeks $5.4 million in damages, of which 95% are non-economic. How realistic is that figure? That may be what he put in the complaint or interrogatory response, but it's probably not something that you could get a jury verdict for or sustain it. So to me, the key factor is weighing benefit versus burden. And since there was, in essence, it was relevant, that was clear. There was no real burden on the plaintiff to produce all this. It's not quite press the Staples easy button, but you know, it's not a question of finding it, reviewing it, pulling it out. That had all been done. So I think that's why we don't see this all the time. And in the last case we saw it, the name of which is escaping me, Doug, but you know, I found that it was sort of check the boxes in the way that that judge had gone through the 6 factors.
Yes, it's escaping me too at the moment, sadly. But yes, it was I believe it was one of these 7 cases of the year we had at the end of the year. So I'll see if I can find that and throw it out there as we continue. So, so Mary, based on my calculations, 23,700 videos is a little over 4 years, is about 16 videos created per day, every day. I don't know who has the time to do that, but anyway, with so many videos, what recommendations do you have for our audience on how to assess them all as quickly as possible if they need to?
Well, the first thing is a data reduction exercise, and I think the judge started out by doing that, saying just the first 14 days of the month. But that's not a lot of a reduction. There's other mechanisms that can be brought into play. Several of our trusted partners can index videos to make them searchable, and sometimes even without making them searchable in our eDiscovery way. However, they're stored may have some mechanisms for data reduction by person, date, keyword, sentiment. It depends on what they were recorded into. And the partners that can do that are iPro and iConnect. It's a wonderful thing to be able to take a mass of video or audio and make it searchable.
Mm-hmm. Indeed. And it just blows me away how many videos a single individual created here. So just shows what's really possible there. So Tom, do you think Judge Garcia's dismissal of the estimated review time for the videos was fair, or do you disagree with the defendants that the proposed privilege review is an obstructionist tactic?
Well, I didn't think they were obstruction. I'll take the second part of the question first. Sorry. But as far as obstructionism, the judge clearly didn't think so. The judge point blank said, as you just put up on the screen, the requested videos are relevant. And because they failed to demonstrate any burden, that objection is overruled. So, I don't think that went anywhere. As far as the estimated time, I think really the judge answered that in her order by cutting down on the number to be produced. Her order said that they would produce responsive videos for the first 14 days of each month during the relevant time period. So not everything, but the first 14 days of each month. And then she went on to say, if the plaintiffs chooses to review the videos in advance of production and withholds any based on attorney-client privilege, he will amend the privilege log accordingly and produce the amended privilege log with the supplemental production. So the judge left the ability to go ahead and review them for privilege on the table, just cut down on the amount that had to be worked through to deal with that time frame.
And of course, we do not know from this opinion whether there was a Federal Rule of Evidence 502D non-waiver order in the case.
Yes,
but I throw that out.
I'm sorry, I didn't. I'm remiss in saying that. Yes, of course, I should have not overlooked that.
So it's an official webinar now, folks. The 502D has been officially mentioned by Judge Peck. By the way, the case that Judge Peck and I were both trying to come up with was Edwards versus McDermott, which we covered last year in Texas. That was the one where Judge Edison had a light bulb moment to use the 6 proportionality factors and those to assess search terms. So that was interesting there. And just a reminder, because somebody asked, a copy of the slides will be emailed after the session, so look for those. All right, our final case involved disputes over investment management services with an additional case that was filed against the defendants in New Hampshire by an entity also owned by the plaintiff family, where discovery was proceeding jointly with the 2 cases. The court approved a stipulated discovery order on February 27, 2020, which stated ESI would be produced in the following formats: native files. For any production made in non-native format, the producing party shall produce the integrity of the underlying ESI, including original formatting, file structure, e.g. files attached to email, and metadata. The foundation also included all metadata and hidden data, such as that maintained by an application program and metadata maintained about a file by the operating system or by other programs, in the definitions section of its first set of interrogatories and requests to produce. In May 2021, counsel for the foundation asserted several deficiencies with defendants' productions, including metadata issues like at least 9588 documents with missing file names and file extensions, which they contended made it difficult to identify emails, and at least 5,658 documents with incorrect metadata in the date created field. After discovery issues were raised in the other case and the parties conferred by video on August 18, 2022, the Foundation's counsel asserted that they discussed how original metadata had not been retained because defendants acknowledged that they moved documents from where they're stored in the ordinary course of business to intermediary folders in preparation for document production, and that metadata was stripped during this process. Vermont District Judge Jeffrey Crawford rejected the defendant's assertion that the Foundation failed to raise these metadata issues until August 26, 2022, by referencing the Foundation's May 11, 2021 letter, which did raise issues about the metadata in defendants' productions. He also stated, by failing to produce documents with complete and accurate metadata, defendants fell short of their discovery obligations. Because the Foundation seeks metadata for non-email documents, the court understands that the metadata issues relate to a set of approximately 10,000 documents, not the entire 400,000 page production. The foundation is directed to send the defendants a list of that subset of documents, and defendants are ordered to supply complete and accurate metadata for those documents by June 1, 2023. This imposes some burden on defendants, but as the New Hampshire court stated, that is a function of the way in which the defendants chose to respond to the RFPs in the first place. So, Mary, we usually focus on what parties did wrong in a case, but the foundation pushed for a detailed description of the metadata that they expected, which benefited them here. So what can we learn from how they handled that in this case? And what should parties do if they encounter resistance from the producing party in defining metadata requirements?
Well, the first thing is that the rules say form or forms, and in this case, they did the advanced practice of recognizing that material would be produced in multiple formats, but they put forth the both functional and technical requirements that the files and the evidence be able to be viewed in context. So that what you had read earlier, Doug, about for any production made in non-native format, the producing party shall preserve the integrity of the underlying ESI, including original formatting, file structure, files attached to emails, and metadata. And then earlier they also said things had words like that includes metadata fields identifying natural document breaks and companion OCR and/or extracted text files. So they were very, very complete in what they wanted. They were out loud about it, and so they had something to hang their hat on.
Yeah, absolutely. And I think that's one of the things we don't see often enough. And they did a great job here in doing that. So yeah, absolutely. So Tom, based on the facts described in this case, it appears defendant's eDiscovery provider may have moved documents to new folders in a manner that didn't preserve key metadata fields like create date. So how should those files have been collected to avoid this issue?
Well, before we throw the vendor under the bus, in reading the judge's order
Yes.
on the motions to compel, it's not clear to me that that's what happened.
Okay.
It's clear they were put into different folders, but apparently in at least one Zoom meeting and another exchange, the attorneys said that the client moved them in preparation for a production, perhaps for a review by an expert witness. So it seems unclear to me who did it. Mm-hmm. The vendor that was named in the order is a highly reputable, well-known national vendor,
Right.
And would seem to me would be aware that moving data will change the metadata. I mean, that's a pretty basic principle. That how should these have been collected to avoid the issue? Well, a forensically sound copy, and then put a copy aside, so that if something like this ever comes up, you can always go back and say, well, wait a minute, we've got the original forensics grab sitting over here, and we can still go back and get that. It's not clear to me that this was done on the collection or after the collection. Mm-hmm. But either way, obviously you should have enough knowledge that moving data changes metadata. And in this case, it apparently, however they moved it into a new folder, stripped the metadata out. That might be part of the vendor production. It's just unclear. But in addition to making a forensically sound copy, use a metadata-friendly eDiscovery software. Again, I presume this vendor would have done that. And look, if you want to move stuff around, excuse me, containerize them, right? Put everything into a zip file. So zip the documents up, put the zip file in a new folder, and the original metadata will be contained inside the zip file. So there's a way to do it, but I think the ultimate lesson here is, again, if we're assuming that the client might have done it themselves, is don't try this at home.
Indeed. And it's important to point out that forensically sound collection doesn't mean a bit-by-bit forensic image or what have you. There's plenty of ways to collect data in a forensically sound manner to preserve the metadata. And you noted a few examples there, which are absolutely 100% correct. And I'm not sure it's entirely clear who did it. I did know that the ruling at one point indicated that the eDiscovery vendor was responsible for collecting the data, but again, still hard to say for sure. So regardless, like Tom said, don't try this at home. Do it in a forensically sound manner. So Judge Peck has noted in this opinion that this case paralleled one in New Hampshire involving another entity owned by the plaintiff family, and discovery in the two cases proceeded jointly. How common is this, and when is it appropriate to combine discovery for multiple cases that are not combined in a class action or MDL?
It's relatively common, but it's up to the parties and, of course, to the two or more judges who have the cases. If there is going to be document collection, including ESI, that is roughly parallel in both cases, why have it produced twice? There are going to be depositions, and if the issues are sufficiently the same or similar, why have a witness have to be deposed twice? It depends also on the state of the case. You know, if one case is almost done with discovery when the other one starts, that's not going to work very well. If they're both on a fairly parallel time schedule, you know, if one is in the Eastern District of Virginia, the Rocket Docket, that may control everything. But, you know, parties can do it by having in the confidentiality order that anything confidential in case A can also be used in case B, and or the court can get involved, or the two courts or more, and do joint orders, etc. I even had at least one case I can think of where it was a state case as well as a case in front of me, and I reached out to the state court judge so that we could coordinate the two cases. That is something that wouldn't even occur in an MDL or a class action, because those deal with cases in federal court.
Mm-hmm. Yeah, oh, that's very interesting. And it's certainly one thing that was mentioned in the ruling here was the New Hampshire case at one point entered into settlement discussions, but ultimately didn't lead to a settlement. So presumably they stayed in pace well enough for them to continue conducting discovery jointly. So certainly an interesting factor to this case. So now to our contacts page, and we have a date for our August case law webinar on Wednesday, August 30th. That's right, we're doing 2 webinars a month now. Just kidding.
Funny, Doug.
One's plenty. So we'll stick with one. So until then, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. Thanks to all of you for attending, and I'll turn it back over to you, Mary, to close us out.
Thanks very much, Doug. Well, we'd like to thank you, Doug Austin, and eDiscovery for today for anchoring, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. And our thanks to the EDRM community for your kind attention today. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everyone.
Thanks, everybody.
Bye, all.